Okay, good afternoon, everyone. And I think it's about time to start. First of all, on behalf of the Faculty of Law, I would like to welcome Professor Andrew Harding, our legend, to our Faculty of Law. And today, I'm very pleased and honored to co-lecture with him on the topics of constitutional amendment in Asia. And we are going to present our chapter in a book edited by Professor Buingokson and Professor Mara Marakodi on Asian Comparative Constitutional Law, Volume 2, Constitutional Amendments. Professor Andrew will speak on his chapter on constitutional amendment in Malaysia, and then I'm going to talk about my work on the Thai experience. I think first I'm going to present as we discussed on Saturday, and then Andrew will give his view on the Malaysian experience, together with the comparative perspective between Malaysia and Thailand. And in the final part, I will add some comments, and at the end we will open the floor for the participants to share your ideas with us. Okay, so I think that the lecture will be approximately 2 hours. I think maybe two or 2.5 hours. Not more than that. I think we can finish before 5.
Depends on the questions.
Depends on your questions. Yeah. Okay. So.
I'm not going to talk that long.
Okay, but anyway, yeah, we weren't going talk that long. Okay, so first I'm going to present the Thai case. Okay, so this is the picture of the book that that we contribute our chapters for Son and Mara. Of course, it is a great opportunity for us to present them for the first time to the audience. Okay, so let's start with the Thai case. In my chapter, which is chapter 13, a very good number. In my chapter, I try to access the struggle for dominance between the two competing notions of constituent power, which I call the liberal democratic constituent power and the loyalist conservative constituent power. The point is that I try to access how and to what extent that struggle influences the rules and practices of amending the 2017 Constitution of Thailand, which is the current constitution of this country. And I'm going to use the framework, which is called the binary star scenario, to provide the contours of the effects of the struggle as such on the rules and practices of constitutional amendment in Thailand. This is the sequence of my presentation. First, I'm going to speak about the relationship between the two competing notions of constituent power, and then I will provide the ideas of their views towards constitutional amendment. And in the second part, I'm going to talk about how the struggle between the two competing notions of constituent power affect amendment rules of Thailand's current constitution. And in the last part, I will shift my focus to the practices of constitutional amendment, recent practices. Okay, so let's start with the first part. Now we have to first try to gain insights into the idea of what is constitutional amendment power. And here in my chapter I use the thesis provided by Professor Yaniv Rosnai to explain the nature and scope of constituent power. Well, as I put it here, constituent power refers to the power to establish the constitutional order of a particular state. And the thing is that the power to amend constitution holds or shares some character of the constituent power, because this power allows parliament or sometimes the people to to change, constitutional provisions. So as I said, it possesses the character of the constituent power. But at the same time, we have to keep in mind that the power to amend the Constitution itself is a kind of constitute power. It is a constitute form of power because the scope of the power as such is determined by the constituent power. Also, we can notice that an amendment provision enshrined in most constitutions across the globe theoretically embody some, I would say, some core values of or what scholars normally call the basic structure of the constitution of that particular constitutional order. And according to Professor Rosnay, these core values are designated by the constituent power itself. We can also notice that episodes of constitutional amendment themselves typically reflect the struggle between different political interests within a particular society to assert their political dominance within that society itself. And my point in this presentation, as well as in my chapter, is that in Thailand there is a struggle between the two notions of the constituent power, the LDCP and the RCP, and of course their struggle in effect influences the pattern of constitutional amendment in this country. So now let's focus on I would say the contours of the two competing notions of constituent power in Thailand, and how I would say how the rationale behind these notions shape the view towards constitutional amendment. So let's start with the liberal democratic conception of constituent power, or the LDCP. Well, according to this notion, the people are perceived as a kind of active citizens. So this means that they are perceived as the holder of the constituent power who have the right, as I put it here, they have the right to define and redefine their constitution. They are, of course, actual and active force in a constitutional amendment process. So this means that the state must guarantee the people to play an active role in constitutional amendment process through means, for instance, a public referendum or a kind of popular elected constituent assembly. On the other hand, this idea in Thailand is is compromised by what I call the loyalist conservative notion of constituent power. Well, according to this idea, as I put it here, is by and large supported by the loyalist conservative elites. And according to this idea, it says it believes that the people are the holder of the constituent power, but their actual assertion, is done through the king. So this means that the king is perceived to be the embodiment of the people. And at the same time, parliament in Thailand is perceived to be, the nest of corrupt politicians. And it must be, it needs to be monitored by the monarchy and the loyalists. And under the RCP, the monarchy and the form of state, which is the unitary state, are thought to be sacred and unamendable. On the other hand, Western constitutional norms, especially the notions of human rights, are perceived to be amendable. They are temporarily and susceptible to amendment. Okay, so now, as I just said, in my chapter and in my presentation, I use the framework called the binary star scenario to access, the rules and practices of constitutional amendment in Thailand. But first we need to know some background. I mean some historical background of the current constitution of Thailand. The 2017 constitution. Well, as many of you already know, the current constitution of Thailand was made by the junta. It was, I would say, it is the product of a coup d'etat in 2014, launched by the NCPO, and this constitution, reflects the attempt of the royalist conservative elites to reinforce the RCP. Actually, I talk a little bit about, how the elites in Thailand, the Thai elites, use the constitutional mechanisms to suppress liberal demands through the constitution in the first volume of this book. Perhaps, for those who are interested in this topic, you can, borrow the book by Son and Mara. But anyway, my point is that, but first I have to say like this, the binary star scenario is, what is the binary star scenario? Well, the binary star scenario, as you can see from this picture, it is a kind of universe. Actually, Andrew inspires me to use this framework to analyze the Thai situation. Well, the binary star scenario reflects the kind of two stars which exist in the same universe, and the two stars they are gravitationally pulling each other with no absolute winner. And this is akin to the current situation in Thailand, because in Thailand the loyalist conservatives and I would say the pro-democracy faction, they are competing with each other nowadays, right? And there is still no absolute winner, despite the fact that the loyalist conservative factions holds the upper hand in politics. But at the same time, the elites, they are unable to totally reject the LDCP. As I will show, this also reflected in the rules of amending the current constitution. Okay, so now let's focus on the function of. Let's focus on the rules of amending the 2017 constitution. Well, there are two provisions regarding constitutional amendments enshrined in the current constitution, section 255 and 256. And in my paper, I point out that there are three tiers of constitutional amendments in Thailand, from the most difficult one to the most lenient one. The most I would say the highest tier of constitutional amendment in Thailand is reflected through the eternity clause, section 255, because this section contains a kind this section is a kind of an eternity clause. It says that the form of the state and the regime of the state are unamendable. So this means that in Thailand, it is unconstitutional to change the regime of the country from the democratic regime with the king as head of the state, or the RKH, to a kind of republic or something. And at the same time, it is unconstitutional, to change the form of state, which is a kind of the unitary state, to a kind of federal state. And what is very interesting is that the constitution creates some kind of veto mechanism within this provision, because it allows the constitutional court to play a vital role in checking whether an amendment contravenes the eternity clause. So as I put it here, it appears that in Thailand, the idea of the constitutional court, which is supposed to be the guardian of the LDCP, is exploited to protect the unamendability of the monarchy, which is the core of the RCP. This is the highest tier of amendment. Now let us turn to the second tier of amendment. I call this fundamental amendment. This is the first time. This is the 2017 Constitution is the first constitution that creates or provide rules on fundamental amendments. According to the current Constitution. This one. So I start with this one first. Well, according to this Constitution, the rules on human dignity and the provisions on royal prerogative powers enshrined in Chapter 2 of the current Constitution are amendable. But if you want to amend these provisions, a referendum is required. So this means that the 2017 Constitution requires that a proposed fundamental amendment be ratified in a public referendum, which is the idea or the core of the LDCP. And as you can see, this Constitution appears to turn, I would say, to turn, the pillars of the LDCP, that is, the people, into a kind of a shield that protects the core of the RCP. And now let's turn to the third tier of amendment, the normal amendment. This provision is it just expired, but it is important to mention it. Normally, if you want to amend the 2017 Constitution, I mean its general provisions, the Constitution allows eligible voters, 50,000 eligible voters, the right to propose a constitutional amendment motion. But at the same time, it says that in order for an amendment motion to become effective, it must be approved not just by the MPs or the House of Representatives. It must also be approved by the Senate. And as many of you already know, before May 2024, not 14, I mean 24, I mean pre-2024 version of the Constitution. I mean before this month, in the past, the current Constitution of Thailand allowed the NCPO, or the junta-appointed Senate of 250 members, the right to vote alongside MPs in approving a constitutional amendment proposal. And I mean, if you read news on Thailand, you can see that there were several attempts, to propose constitutional amendment motion to abolish the Senate itself, but it was the Senate itself that disapproved, those motions, right? So this reflects, the kind of, attempt by the drafter of the current Constitution to use, kind of the RCP based, mechanism to forestall, the LDCP in this country. Okay, so we talk about the rules of amending the 2017 Constitution. Now let us turn to the practices of amending 2017 Constitution. Here, I would like to, give you, 2 cases delivered by the Thai Constitutional Court on constitutional amendment. Well, actually, in the past 4 years, there are a lot of, attempts, by MPs of both, the Royalist conservative faction and the progressive faction to amend the Constitution. At least, there are a lot of people here who think that, this Constitution, is a kind of, an obstacle to constitutional development in this country. Of course, there are demands, to amend it, right? But only so far, only one proposal succeeded. And at the same time, it appears that the Constitutional Court itself, played a vital role in, I would say, in forestalling the attempt to democratize the current Constitution. Or to put it another way, it appears that the Constitutional Court itself, an instrumental role in protecting the RCP. And as I just said, here I used, two cases as an example. The first cases was in 2021. This case, involved the demands for monarchy reform put forward by a group of student activists known as the People's Party or Khanak Rasadon. At the time, these activists, organized a kind of protest at Thammasat University, and they proposed, some demands, including monarchy reform. They request that section, I forget the exact section, but anyway, it is called the inviolability clause enshrined in the Constitution, which says that the monarchy is sacred and inviolable. They propose that this inviolability clause be abolished, and this is the proposal. And at that time, there was an activist, a loyalist activist, who lodged, petition before the court, the Constitutional Court, asking the court to declare that proposal unconstitutional, and an attempt to overthrow the monarchy as well as the RKH, the democratic regime with the king as head of state. Well, the court, ruled that the action of the students was unconstitutional, and more importantly, the court says that the inviolability clause itself, which guarantees, the sacred and inviolable status of the king is unamendable. This is quite interesting because if we look at section 255 of the Constitution, it just says that only the RKH and the form of state that are unamendable, right? But the inviolability clause itself exists in chapter 2 of the Constitution. But the court, expand, the scope of the eternity clause. So if we use the term, provided by Professor Richard Albert, this type of unamendability is called interpretative unamendability. It's a kind of unamendability that is created by the judiciary. Now let's turn to another case in 2021 as well. This case, affects, the current attempt to democratize the 2017 Constitution enormously. This case, involves, the attempt by the Pheu Thai party in the past, as well as some other parties, to amend the Constitution, to amend the 2017 Constitution by including a new chapter on new constitutional making. So this means that at the time the Pheu Thai party and other parties they proposed a motion which includes a new chapter on constitution making, and they propose that a new constituent assembly be created to draft a new constitution. However, the court ruled that the attempt to add the new chapter, which is called chapter 15/1 on constitution making, would entail constitutional replacement. So the court, distinguished between amendment and replacement, and it says that the attempt to add new chapter on constitution making would entail replacement. It is not amendment. So this motion, becomes unconstitutional in effect. But the thing is that as I just put before, we should always remember that the current Constitution of Thailand was created by the junta, by the NCPO. But it appears that the court try to protect this constitution through the people. Why I say this? Because if you read the whole decision, the court itself did not close the door for constitutional amendment. Instead, it says that if Parliament wishes to amend the current constitution, it has to arrange two referendums. The first to ask the holder of the constituent power, the people, whether they want a new constitution, and the second to let them approve the complete draft. So this means that if you want to change this junta-made constitution, you have to ask the people, right? And of course, as you know, the current situation in Thailand, there is a struggle between the I don't use the word red and yellow. There is no red and yellow at all now, right? So I would say that there is still a kind of conflict between the loyalist conservative mass and the pro-democracy supporters. So I would say that it appears that the court tends to turn the people into a kind of a mechanism for protecting the constitution, which aims to reinforce the RCP. So this is the Thai experience, and now I would like to give the floor to Professor Andrew, and then we will try to compare the two cases together. Okay. Thank you.
Right, thank you very much, Rawin, and thank you all for coming along to the seminar. It's very nice to be back at Chulalongkorn University and to see you all here. Okay. And we have lift off with the screen, so we seem to be good to go. All right, my chapter is about constitutional amendments in Malaysia, something that I seem to have been concerned with for a very long time. And so I was wondering, what on earth can I say in this chapter that hasn't already been said many times over, not just by me, but by others. All right, so what I'm finished up with and what I'm going to talk about is, first of all, the actual process whereby the constitution gets amended in Malaysia. Then I'm going to talk a bit about special cases where you have provisions that don't apply right across the board, but only in particular instances. And then I'm going to talk about the evolution of constitutional amendments as a matter of constitutional amendment practice as opposed to law over a period of time, and identify three different periods, and finishing up with constitutional amendment as it is now, and then some comparative conclusions, where I'll come back to sort of thinking about what the relationship might be between Thailand and Malaysia and what we might learn from it. But you'll quickly get the idea that on the face of it, there seems to be very little that we can compare, but we can probably do better than that when we get into it. Now, I thought I'd just start by showing you this relatively recent headline from a Malaysian newspaper, and if you here understand that the basic rule in Malaysia is that you need a 2/3 majority in both houses of parliament to amend the constitution. There are other requirements in certain cases, as I mentioned, but this is the fundamental rule. It's amazing how much importance is attached to this rule. And for many years, opposition parties used to campaign in elections on the slogan, "Deny them 2/3", which you might think is a rather puzzling slogan for somebody to campaign on. But the idea was that the whole electoral system was slewed in favor of the government, and you couldn't really make any progress unless the government was stopped from amending the constitution, because they had done it so many times. So in discussions with Rawin about this, we sort of reached a pro tem conclusion that the two cases are different in the sense that in Thailand, when you want to amend the constitution, you just adopt a new constitution, usually after a military coup and a constitution-making process, a temporary charter, and so on and so forth. Whereas in Malaysia, if there is a constitutional obstacle, you just remove it by constitutional amendment. So that seems to express the difference. So this idea, the two-thirds majority, is very much part of popular imagination. Even in newspaper headlines, it refers directly to the constitutional provision. And somehow the idea that any government that has a two-thirds majority is inherently untrustworthy because it might start amending the constitution. And you might wonder, well, why is this constitution so precious that nobody is allowed to amend it? I think that's a very good question, because there are lots of problems that you might think, and we'll see there are examples of this, that there's such a thing as a positive amendment, not necessarily a wrecking or abusive amendment. But that's an issue that we'll come back to. So what is the rule? Well, okay, first of all, there has to be a bill for amending the Constitution, right? Now that might seem obvious, but it's actually quite important, because the bill has to be on its face a constitutional amendment bill. In other words, if you passed a law with a two-thirds majority in both houses, which was inconsistent with the Constitution, that would not be a constitutional amendment, because it has to be expressed on the face of the Act. There is no such thing as an implied amendment, and you therefore also cannot wrap up a constitutional amendment in a bill that does other things as well, like a tax statute or something like that. So it has to be transparent in that sense. And then you need a two-thirds majority of all the members, not just the ones present and voting, in each House of Parliament. For some amendments, the consent of the Conference of Rulers, Malaysia's 9 monarchs at the state level, is also required for certain amendments which relate to Malay rights, the monarchy, or the position of Islam, and one or two other matters that are specially protected by the monarchy as well as the two-thirds majority. And some of those provisions are actually of great importance. And then amendments affecting Sabah and Sarawak, and again I'm going to come back to this because it's very important, require the consent of the government in question if the amendment relates to certain matters which are of importance to those states. And it's interesting here, and I've always been puzzled why the veto here rests with the government of the state and not with the legislative assembly. Nobody has ever managed to answer my question why this should be the case, but it simply is. That's what the Constitution says, as amended in 1963, pursuant to the Malaysia Agreement 1963, which has become an important issue with regard to the Constitution and constitutional amendments. So there you just have a little map indicating that, the East Malaysian states are, between them, far bigger than the states of Malaya or West Malaysia, but they only have about 5 or 6 million people, whereas Malaysia as a whole has about 33 million people. So they have more land and more natural resources, but fewer people. So a lot of these issues are actually now to do with the balance of power between the two sort of halves of the country, if you like. So coming back to the veto for these two states, the veto has not, in fact, I have found, protected Sabah and Sarawak from adverse amendments, or even in some cases from simply ignoring constitutional requirements. There have been cases where the veto has not even been, a consent has not even been sought in relation to particular amendments when it probably should have been, because that's what the Constitution requires. And currently, interestingly, there is a case being brought by the Law Society of Sabah against the federal government, alleging the federal government has never made constitutionally mandated grants to Sabah since 1974, and they're suing for back payment as well as continuing, transfer of those grants. So there's a lot of feeling and a lot of politics and a lot of litigation now around this kind of balance between East and West. An example of this is that back in 1988, probably the most famous constitutional amendment in Malaysia was one that affected the jurisdiction of the Sharia courts with regard to the ordinary civil courts, basically preventing the civil courts from interfering in decisions made by the Sharia courts, the Islamic courts. And no consent by Sabah or Sarawak was ever obtained to this amendment, even though judicial arrangements are part of the protected areas that should require consent. So I think this shows you the extent to which over the years the federal government has simply kind of often just ignored the constitutional amendment process. And the attitude has been, well, if you get a two-thirds majority in both houses of parliament, then that concludes the issue. It doesn't actually conclude the issue, but that's what they thought. Now, interestingly enough, on this theme, there is now a proposal to amend the constitution to ensure that Sabah and Sarawak, between them, will always hold 35% of the seats in parliament. Now, you can see why 35%, because you need 66.6 recurring percent in order to amend the constitution. So if you control 35% of the seats, you can stop any constitutional amendment being passed. So it'd be interesting to see where that particular proposal goes, but you can understand why it's being put forward. So I thought that what I should do for this chapter, apart from setting out the rules, and in fact part of my thesis is that the rules don't tell you a great deal about how constitutional amendment is actually pursued in Malaysia. I thought I should look at the actual facts over, since 1957 in terms of what has actually happened with constitutional amendments and how it has happened. That was one of the questions that was posed to us. I mean, how do constitutional amendments take place? Who has power over this issue? What process is adopted? Not necessarily just formal constitutional process, but what other processes are there? For example, consultation, public education, and all the rest of it around that. Now, shockingly, we found that there have been an estimated between 600 and 700 individual textual amendments to the 1957 Constitution since 1957. Obviously, most of those are very kind of trivial, just substituting one word for another or whatever. But on the other hand, there have been 59 amending acts. So think about that. That is almost one act every single year that amends the Constitution. In retrospect, it's surprising that any of this constitution has actually survived this process, because there's almost nothing that has been beyond the scrutiny of the legislator when it comes to constitutional amendment. And actually, again, drawing a parallel with Thailand, even the monarchy has not been excluded from constitutional amendment. There have been two major constitutional amendments affecting the power of the rulers in Malaysia. So it's not off limits, in spite of the fact that it's a sort of specially protected area because of the consent of the Conference of Rulers. So looking at this over the span of years, I was able to come up with the fact that there are three periods here. The first period is the period of the dominant party system between 1957 and 2008. So for most of these amendments were carried out during that period. During that period, the Barisan Nasional Coalition was a dominant party or dominant coalition which not only won every election, but won almost every election with a two-thirds majority. And that was an outcome of the electoral process. Doesn't mean they had two-thirds of the votes, but it means they got two-thirds of the seats in Parliament because of the skew-iffy nature of the Westminster first-past-the-post electoral system, which had actually been interfered with by constitutional amendment in order to give an advantage to the ruling coalition. So there were many what we would call illiberal or maybe even abusive amendments during this period, and it would take me a long time to go through even the most important of these, so I'm not going to try. But I will present you with the most extreme example of abusive amendment, which is quite extraordinary, because back in August 1965, Singapore was expelled from the Malaysian Federation by means of a constitutional amendment. And this bill passed all of its stages in both houses of Parliament with the requisite majorities within the space of one morning. No notice having been given before that morning to any of the members of Parliament or the senators who had to vote on this issue. So, you know, it was a very rapid expulsion, and there was really no debate about the significance or, you know, whether or how this should be done. Everything was just closed down, and you just vote for the bill and job done. By lunchtime, Singapore is on its own. I mean, it is an absolutely extraordinary process, which you know, obviously makes us quite suspicious of the idea that constitutional amendment should be in the hands of any single body. And I think there's a certain sort of naivety by constitution makers, here it was the Reid Commission in 1957, to think, you know, that you can protect this whole apparatus that you've drafted, the Constitution, just by having a special majority in Parliament. No such thing. That's been proved to be wrong on so many occasions. It's difficult to find any example where it's been proved right? So, I mean, going back to 1957, the idea that they put forward, I think they devoted about 2 sentences in their report to the issue of constitutional amendment. That's how importantly it featured in their imagination. To say, well, the Constitution should be neither too rigid nor too flexible, so we'll have a 2/3 majority. Right? I mean, this is simplicity. You know, that the word banal does not even capture, you know, the extreme foolishness of the assumptions behind those sentences, as has been many times proved over. So, on the subject of well, how you get the 2/3 majority, well, basically, the government managed to secure constitutional amendments which flooded the Senate with people who were appointed by the government, not elected at the state level, which was the original idea. And I think there's a Senate not too far from this spot, which you could say, you know, exhibits some of the same characteristics that I'm describing, and therefore the Senate has never acted as a check and balance against the lower house, because basically most of the membership of the Senate owed their position to direct appointment by the government, so they were kind of, you know, political appointments, and they're not going to vote against the government. So 2/3 is guaranteed. Now, for the lower house, they actually amended a schedule to the Constitution to ensure an extraordinary degree of malapportionment in electoral districts, so that rural districts have as few as 17,000 voters, and some urban districts have as many as 117,000 voters, which obviously weights the electoral system in favor of rural constituencies as against urban ones, which really, to be equal and fair, they should have about 10 members each, not just one. But anyway, that's how it is. So there's no proper, you know, there's no kind of margin of error that attaches to this. And the result is that parties that can control the rural vote can control Parliament. It is really as simple as that. So they were able to get a 2/3 majority with around 50% of the actual vote. And then in 1988, as I mentioned, the removal of the judicial power from Article 121 of the Constitution was very, you know, important amendment, which restricted the power of the judiciary. And it was not certain, well, if you have a judicial power and then you remove the words judicial power from the provision, what then happens? I mean, is the judicial power still there in some way, or because it's been removed, that means everything is just according to statute and there's no real judicial independence? Well, thinking of the issue of interpretive amendment, as Richard Albert called it in Rawin's presentation, the courts have recently, in effect, reinstated the judicial power by saying, well, the Constitution may not use the words judicial power, but it's very obvious that the separation of judicial power is a very important feature, which is implied by everything else that you might read in the Constitution. So we have no difficulty with the actual removal of the words from the text of the Constitution. So for 50 years, the concept was that executive power was based on an electoral mandate, however that was achieved. Party was the protector of the people and of the Constitution, and the ruling party could amend the Constitution whenever it found it suitable to do so. And it repeatedly, on many occasions, did that. Each amendment gave the executive more power than it had before, to put it very simply, including restrictions on the royal power that were enacted by amendment in 1984 and 1993, removing the power of royal assent to legislation, and then removing sovereign immunity so that the rulers could be brought before a court of law if they acted unlawfully. Those you could say, well, those are not exactly abusive constitutional amendments, and that's probably right. But on the other hand, they did give the executive more power because it prevented the rulers from acting as a check or balance on the prime minister and the cabinet. So they conform with the matrix of giving the executive more power. So what about the second and third periods? Well, coming down to the second period is 2008 to 2018, where astonishingly there were no constitutional amendments. And that was because in 2008, the Barisan Nasional lost its two-thirds majority in Parliament and was not able to get it back again. And in fact, as you probably know, in 2018, they lost power completely in that election, and they now control only 30 out of 222 seats in Parliament. So the collapse of the BN vote has been absolutely extraordinary and has had dramatic effects on constitutional entrenchment, constitutional amendment since 2008. So initially, 10 years, the Constitution is frozen in time. The government cannot pass any constitutional amendments. The opposition can't do that either, because you effectively, as I argue in the chapter, you cannot have a constitutional amendment unless the government promotes it. It all has to go through the government. In theory, you could have amendment by a private member's bill, but it's never happened. It's never been seriously proposed, and it's not a practical proposition. You need the government to support a constitutional amendment. And then we've got the third period. So I don't know why I've numbered them in that way. That's wrong. The third period is 2018 to the present, in which, again, the political context has changed because there's been political fragmentation with 4 prime ministers, from 2018 up to date, and several changes of government. During this period, because of the decline of the power of the executive, the power of the judiciary and the monarchy has increased, almost as it were to fill the vacuum created by politics. Suddenly judges start striking down things that the government does. The monarchy starts intervening in political matters and deciding who is going to be the prime minister and things of that kind. So you have a totally different situation. And critically thinking back to the East Malaysia issue, during this period, for the first time, Sabah and Sarawak have held the balance of power between government and opposition. And that gives them a tremendous amount of leverage to get constitutional positions by amendment if necessary, that they have long sought for, but they're now in the position to demand, because otherwise you can just switch your support to the other side. So the rather curious outcome of all this is that during the last 5 years or so, we've had a period of liberal constitutional amendments achieved not by executive fiat, but by consensus. And conceivably, that's exactly where the Reid Commission imagined that the Constitution, should be, but it's taken, about 60 years to reach the position that they imagined, namely that, you should only amend the Constitution in order to improve it, not to destroy it, and that you should only do it where there's a broad consensus, not simply the ambition of one party to get things to its own advantage. And on the I don't want to go really into the basic structure doctrine, other than to say that those issues that Rawin discussed have also recently featured in case law in Malaysia, where there are some contradictory decisions about whether basic structure doctrine applies in Malaysia. But the fact is that it has not so far been used to strike down any constitutional amendment, in fact. So they've sort of kept the door open that this is a potential area of argument, but it's not something that has directly affected the power of constitutional amendment at this particular time, although it could do in future. Right? So what do I mean by these so-called liberal amendments since 2018? Well, Sabah and Sarawak were subject of amendment in 2022, which had the effect of listing those two states separately from the other states as territories rather than states within the Malaysian constellation. And that doesn't immediately have any practical effects, but it has immense psychological effects. And in fact, it is now leading to other claims being made by Sabah and Sarawak, which have constitutional ramifications. So we can expect future constitutional amendments relating to this issue. And the Malaysia Agreement under this amendment has been listed as one of the foundational documents of the country. In other words, you can now use the provisions of the original Malaysia Agreement to make constitutional claims that can be litigated and are in fact being litigated in the courts. And that's a very important platform for moving forward with positive constitutional amendments. Another one was the anti-party hopping amendment in 2023, which meant that if you cease to be a member of the party for whom you were elected in the election, then you lose your seat in Parliament, and therefore there has to be a by-election. This is in order to prevent individual members and whole factions from shifting their support from one party to another, because they'd all then have to fight again for their seats in Parliament. And this has had a dramatic effect on political stability, because since that was only brought in sorry, I think I got the date wrong. It was October 2022, not 23. So for the last 18 months, that's been in force. It affected the November 22 election and has created, for the first time since 2018, governmental stability. So this is a good amendment that was very much needed and has succeeded in doing what it was intended to do. Now there is a proposed amendment to do with citizenship that would give children of Malaysian women who are born overseas the right to be Malaysian citizen, as opposed to children of Malaysian men born overseas. So this is a gender equality provision, and I'm pretty sure that will be passed, because these amendments have been achieved by consensus. There have been almost no votes in Parliament against these amendments, right? And in most of the cases, it's a result of long advocacy, either by the civil society or by representatives of Sabah and Sarawak to protect their autonomy, resulting in the government deciding to introduce a bill, and then the amendment goes through very smoothly with basically nobody against it. So this is totally different from what happened for the first 50 years. And this prompts me to say that, when we look at the rules on constitutional amendment, we're probably missing the point completely, because the reason why this has changed so much is not the rules have remained the same, but the context has changed dramatically. And it's that we need to pay attention to. It's no good saying two-thirds majority. A special majority protects against unwarranted, unwise constitutional amendment, because it simply doesn't. And probably no special majority is really going to do that. So the political alignment is what has affected the reality of constitutional amendment, not the rules themselves. That's not to say that the rules are not important, because I think we can think of, and Rawin was in his presentation thinking of, ways in which we can improve the constitutional amendment process to make it more democratic, more consultative, involve more bodies, more institutions in the process, not just Parliament. Right? So the scope for constitutional amendments that would improve constitutional amendments. Because as Hans Kelsen said somewhere, I've never managed to track down where. He's supposed to find out for me. But Hans Kelsen said somewhere that the rule on constitutional amendments is the most important rule in the legal system. Well, okay, in Thailand it isn't, I agree. It's not in Thailand. But in most countries, this makes sense because it determines the degree of entrenchment of the constitution itself, on which all of the other laws depend. That's why Kelsen allegedly said that. I think he said that. So it is extremely important, and we cannot just deal with it in two sentences. We have to have a much better process for amending the constitution than we have in most countries, including in Malaysia, where this has not been a terribly positive position. So what are the lessons to be drawn? Well, as I say, special majority, which is a common form of compromise between rigid and flexible constitution, is not a foolproof guarantee. The idea of a rigid and a flexible constitution is really a mirage. It depends on the politics and who is able to fulfill the requirements and in what circumstances, not what those requirements actually are. States' rights, fundamental rights, civil liberties, judicial power, and so on are all vulnerable to a parliamentary majority. The process needs to include elements other than Parliament itself. No amendment is in effect possible without government initiative in Malaysia. But I think there's a lot of mileage in the idea of a people's initiative for constitutional amendment, which you were talking about, but is actually in the constitution in the Philippines. There's some good law in the Philippines constitution. Is much more democratic than we find in most countries. But ultimately, the balance of political power is the only real guarantee of responsible constitutional amendment. All right, this is comparison with Thailand is something that we're scheduled to talk about, but maybe I can just introduce that by saying that obviously the politics of the two situations is very different and affects clearly what we mean by constitutional amendment, how it's done, and what its significance is. So, for example, the whole idea of constituent power, which is where Rawin's presentation started, has not even arisen in the Malaysian context because they've only had one constitution since 1957, and there hasn't been any military coup, and no constitutional amendment has been alleged to give rise to a problem of constituent power. Maybe it should have done, but in practice that has not happened. So it's dealt with in a very matter-of-fact way. Either you have a two-thirds majority or you don't. As simple as that. There's no kind of idea, until the basic structure doctrine came on the scene, that there might be limits to this power of constitutional amendment because you are raising the spectre of constituent power rather than constituted power. So this is an interesting difference. Monarchy is an amendable situation in Malaysia, as distinct from Thailand. So I've discussed that somewhat in the paper. It's sort of interesting to see that you get different conception in these two countries about how a constitutional problem should be solved. Right? Instead of Thai solution, military coup, temporary constitution, new constitution drafting, elections, civilian government, and so on and so forth. In Malaysia, it's just been a matter of whether the government of the day is able or is willing to institute the process of constitutional amendment, which makes it a matter of political power. I mean, who can plausibly make a demand for constitutional amendment that would have to be responded to? So that's the basic difference, as I see it, between the two cases. So I'll just stop there. Thank you.
So we should pass the floor for discussion.
Yeah, I think so. Yes.
I think it's great. Thank you very much, Andrew. And I think we still have some time left. And I think I would like to pass the floor to our participants to share your idea with us. Okay, so please.
Thank you. When I saw Professor Andrew, it's like about 10 years of no amendments at all in Malaysia. I started thinking about compared to what Thai constitutional experience, and when I first read Dr.Rawin binary star concept, when you comment on my thesis, I started thinking that the binary star scenario that you mentioned in your work is not just a privilege of the current constitution, but it actually is like a situation that occurs in the 1932 when the revolution took place, but it's not like a binary star between like the different political ideology, but the binary star of different political faction. Those like loyal to the crown and those with like the new political elites in the country, right? So I think like in case of Thailand, when we're thinking about constitutional amendment, those in power are put in extreme condition, win or lose. So one group want to preserve that constitution. So if they lose, it means they lose it all. So the amendment, they will protect the constitution and not allow amendment. And for another side, because they cannot amend the constitution, the only way to change their political stand is to military coup or something like that, which is not happen in Malaysia. So I think that is my thought. I think we need more research about what actually happened in terms of political context, and the comparison should be interesting.
I think we're not quite sure what the question is, but we take on board your comments.
Not a question. I think it's just like my thought about what related to your presentation. So that's just my thought. Not a question.
Yeah, okay. Well, I mean, I think what you say makes a good deal of sense. The difficult question is sort of, well, why is it so different? And it's, I think one of the good things about constitutional evolution in Malaysia is that they've managed to avoid the military involvement that you've seen in Myanmar, Thailand, the Philippines, Indonesia, right? The monarchy, the military doesn't seem to feature, although there are suggestions, and it's never been made terribly clear, but there are suggestions that when the issue of the royal assent came up in 1983-4, people felt that there was a danger that the monarchy might actually be abolished. And there is a story that the head of the armed forces went to the Prime Minister's office carrying a copy of the Constitution and informed the Prime Minister that he, the general, had sworn to protect and defend this Constitution, which is interpreted as a kind of a hint that, well, you know, you better not go any further with this issue because you might guess what could happen. But that's the nearest thing that I've ever heard to a suggestion that there might ever have been a military coup in Malaysia. And I can't offer a terribly good explanation as to why this is the case. Perhaps it depends where you start from. And if you start in 1932 with a military coup, and that executes a fundamental change, that suggests that military coups are quite a good thing, right? Whereas in Malaya, you start with, well, you know, the military dealt with the communist insurgency, but it did so strictly under civilian control, first of all under the colonial rule and then under post-independence, you know, constitutional rule. But in all of those cases, the military was strictly under control of political decision-making. It didn't have its own discretion. So I guess part of the explanation is just the history and where you started from, and then you just continue along the same line. Does that make sense? I don't know.
Yeah. And also, in my opinion, can I add something here? I also noticed, you know, I would say some similarities in, you know, recent year between the two contexts. You know, at least, you know, we can notice that there is a growing trend, you know, in you know, both countries that constitutional amendments tend to be, you know, to be used. You know, I would say that there are some people, you know, who start to think that they should use, you know, the constitutional amendment mechanism, you know, to democratize or improve the constitution. You know, as in Malaysia, right? You know, the anti-hopping amendment recently, or in Thailand, you know, despite, you know, that there further, you know, there are attempts, you know, to you know, propose, you know, the Chapter 15/1 to, you know, create a new constitution that is much more democratic. So at least, you know, we can see, you know, some democratic trends, you know, in both countries. Yeah.
Yeah, I mean, I think this is an interesting and important point, but I just want to be clear here. It's not that suddenly Malaysian politicians have become constitutionalists, right? I mean, that's not the story. It is about making strategic decisions and political necessity. So, you know, you may think that it would be very good to have a constitution that's completely in your favor, but the problem is if you then lose power, all of those powers can be used against you. So you should be very cautious about these kind of executive-oriented, you know, amendments, because, you know, it may come back to bite you if you go too far with this, and therefore you have to have a more holistic view of this apparatus, not just the bit of it that might give you an advantage. And the same with the Sabah and Sarawak situation, which is driving, I think, a lot of constitutional changes that are happening and will happen in the future, is purely contingent on the politics of the situation. And, you know, I think that it is viewed in that part of the world as simply, well, it's not that, you know, we care deeply about the Malaysian constitution and what it's going to be in future. We care about what is to our advantage, and it's to our advantage to get as much autonomy out of this as we possibly can while we can, you know, because later on it may not be possible. But we need to also ensure that any advantages are not countermanded by a future government. And this is working. They control half the seats in the Malaysian cabinet. With a population of 6 million people, they're controlling half of the government. So the balance of power really works.
Oh, yes.
Victor.
Thanks for a great presentation. Great to see you, Andrew. And I've seen Rawin recently. Couple of thoughts, observations, and provocations. I read yesterday that President Biden was at West Point, the military college, and in his speech, he mentioned that the cadets at West Point were the guardians of democracy. So watch this space. We might see yet another role for a military in preserving or upending a constitution. That's just a observation. I thought it was interesting, the question about politics as, I'm not sure this is quite how you put it, Andrew, but politics as a foundation for constitutionalism. And the East Malaysia situation is interesting because suddenly you have other political voices that are at the table, right, at the constitutional table. And I wonder if that's not part of the story of constitutionalism, right? Having that diversity of voices, and maybe it was an accident, maybe it was a matter of politics that you ended up having these other players that have to be dealt with. It seems to me that having a robust civil society, having robust actors, plurality of actors, that might be something that contributes to constitutionalism from the ground up, right? So I'm not sure I can comment on Thailand, but I do wonder if there's something to be said for the sort of civil society being more engaged and possibly being the font of constitutionalism. And in the end, maybe that's the sort of original conception of constitutionalism, is that it has to come from politics, right? The stability of a constitution can't rely on the text of the Constitution. It has to rely on a political foundation, a workable political foundation. And so on that note, one of my favorite quotations, I'm afraid, is an American thinker, Learned Hand. You may be familiar with his Spirit of Liberty speech, where he basically says that, I just pull it up here, that I often wonder whether we do not rest our hopes too much upon constitutions, upon laws, and upon courts. These are false hopes, believe me. These are false hopes. Liberty lies in the hearts and minds of men and women. When it dies there, no constitution, no law, no court can do much to help it. So going back to this question about politics, workable politics, and again, I think that that's something that Andrew was alluding to, right? That you have this political situation where other players are becoming involved. The discussion is a consensus-based discussion on these constitutional amendments. That's where you want to be. So as someone who is a constitutional law person, although I don't do it as much as I used to, I do wonder if we put too much weight on constitutional texts and not enough on constitutional politics. So that's, I guess, my long-winded question. Thank you.
Yeah, I mean, I totally agree with that. I mean, the text cannot be self-executing. Texts, have to be considered from the point of view of interpretation and who is doing the interpretation and how. And unfortunately, we think that this job is entrusted entirely to the judiciary. But actually, in practice, it isn't. I mean, it's entrusted to everybody, whoever has anything to do with the way in which the Constitution operates, including legislators, members of the executive, kings, presidents, and and the people themselves. I mean, that's where Learned Hand is quite right. I agree in those terms. But for me, this gives rise to a larger question, which is, well, then how are we to sort of assess or encourage this type of politics? Because here we're out of the hands of constitutional lawyers, right? And we don't really understand how all this works because we haven't done sociological projects, to discover what people think and why they think what they think, and what are their sources of thinking. Is it kind of religion or parents or teachers or university professors, or what is it that gives you this kind of idea of constitutionalism? And it's sort of odd that given how important this is, we don't pay very much attention to it. But we probably should do. And I think one thing that to me is very obvious is that we don't teach this stuff in school, largely. I mean, I don't know, maybe in some countries there's a bit of it. But, when I was at school, we were taught these things. I mean, it was called civics, right? And we had extensive instruction in how to be a citizen in a modern democratic society. I don't think those courses even exist anymore. But they should do, because this stuff is far too important to be left to constitutional lawyers. Much more important. It affects absolutely everybody. I mean, as the saying goes, nobody is interested in the Constitution until it becomes interested in them, right? And then they want to know, how on earth could this happen? Who has power to do what? And so on. So we need to kind of broaden the scope of this instead of just keeping our discussions in small seminar rooms with about 12 people. We need to reach maybe we should go on YouTube or something and get it all out.
If I could just respond briefly, I went with my class at Chula the other day to the King Prajapati Museum, and behind that museum is what's called the Democracy Education Center. And it's a really interesting place. My understanding is that one of the institutions that nobody writes about or talks about that was set up by the 1997 Constitution was the KPI, and that this Democracy Education Center, this sort of falls under that. It's funded by the legislature. And just on Andrew's last point, they are trying to educate, so they have school groups come through, and they are trying to educate them on the principles of democracy. Citizens, voting, rights, what it means to be a citizen in a democratic country. It's precisely what you're talking about, Andrew. So I guess I totally agree with you, and I think it's worth a visit if you haven't been to check it out, because I think they're trying to do in a very small way, exactly what you're suggesting, and I guess the question is how you scale that up. But I agree completely. Thank you.
And can I just add that as present and former law professors at the University of Victoria, right, we had a system of sending our faculty down to the city to give public lectures to ordinary people who just turned up to a venue to listen to, some sort of important issue in Canadian constitutional law or whatever it is. And I thought that was a really good mechanism that sort of said, well, look, the university is not just an ivory tower where people write learned articles and so on and get promoted for it, but it's, it is a place for producing ideas that should relate to the community of which it ought to be a part, but frequently isn't, right? And I think actually that particular university is a very good example of a university that really tries to be part of the community, and we should do more of that.
Right. Thank you very much, both to Andrew and to Rawin, for your interesting presentations. I was just asking myself, what about referenda in constitutional amendment processes? just as a background, just a few days ago, the German Basic Law celebrated the 75th anniversary, and there was some who said we should include more direct democratic elements in the Constitution, maybe even in the constitutional amendment processes. But then I thought, well, if we look around Europe, for example, also to the UK, what referenda can do in some cases is not always very encouraging. But of course, I got Andrew's message also that, well, we should try to involve people more and maybe build a consensus so that then the referendum basically just approves the consensus that was found. So we may not have much politicization and it will all be for the better. But I wonder what your position is. So, of course, Rawin also mentioned that in Thailand, now referenda are required on different steps in certain cases of the amendment processes. And it's actually designed apparently to make it more difficult rather than to get maybe a bit of a bigger improvement. So what's your idea on that? Are referenda likely to politicize these processes, or are they actually perhaps valuable tools to build a consensus in society?
Thank you very much, Lars. Yeah, from the Thai perspective, yeah, you just reiterate my point. Yeah, it appears that the notion of I would say that nowadays the notion of direct democracy tends to become more and more important in this country. For instance, the Thailand's last two constitutions, the 2007 and 2017 constitutions, both of which were ratified through the process of referenda, right? So this shows that even the military junta and the royalist conservative faction, they tend to see the growing importance of the notion of direct democracy. And funny enough, when some when the progressive faction tender the amendment to the current constitution, the royal conservative counterpart tends to say that, well, this constitution was approved through the public referendum. It was the people's the product of the people. So I would say that the Thai case tend to provide a kind of counter example that sometimes direct democracy might be abused to protect some form of authoritarian agenda or something. Yeah.
This is I think a really interesting question. You won't be surprised to learn that I take a dim view of referenda because I have been tortured for 8 years by a referendum. So I have no intention of promoting anything resembling that in this or any other forum. But I think if you look at it comparatively, I think your own point was right, that referenda are used as a block, as an obstacle. They're not a way of finding out what the people think. They're a way of stopping things from happening, except when it doesn't work, as in with Brexit. But if you look at, I think I'm right in saying that in Australia they have a referendum requirement, and there has never been a constitutional amendment because the people always vote against constitutional amendment. So in the Australian context, it's an absolute block against constitutional amendment, so that even good amendments apparently can't get through because people just don't trust this whole process, and they will naturally be inclined to vote against it, whatever it happens to be. Right? Unfortunately, that didn't happen in the UK in 2016. But I think direct democracy, absolutely. I'm much more in favour myself of things like citizen assemblies than a referendum, because I think that's a serious investigation of what people actually think about particular issues. And let's say if you had instead of a Brexit referendum, citizen assemblies on Brexit, I think you would have come up with a very different answer at the end. And it would have been an answer that would have carried popular support and would have probably satisfied the majority on either side of of the equation. I mean, the good example of this is how they dealt with the thorny issue of abortion in Ireland, right? Where they start with the position that, some people want to absolutely prohibit, other people want to absolutely allow, and then by listening to each other and listening to what experts and doctors and so on said about it, being more informed, they realize, well, okay, no absolute position is correct. Therefore, we have to find which of the compromise positions is right. So by discussing it, a consensus gradually emerges that it should be allowed, but subject to certain, time limits, controls, and so on and so forth. And then that was the basis of changing the law with what people thought was a surprising degree of popular assent. But that's why.
And then, please.
Loudly enough. Just a footnote, you reminded me about the Australian case, so I looked at the results from last year's constitutional amendment referendum, which was about giving Indigenous people a greater voice in the government. And when it was first proposed, it seemed like it was going to be overwhelmingly approved. I mean, everybody was seemingly in favor of it, and it didn't give them some kind of hard power as you were talking about with the two areas in Malaysia. It just added a voice. But anyway, it went down to a stunning defeat. No 60%, yes 40%, and it was defeated in every state. Yeah, in every state, even Victoria, in which people were expecting it to pass overwhelmingly. So that may be in part to the content, but it also may be in part to what you said, that people just are a little bit reluctant to trust this referendum idea of changing the Constitution in by themselves. I don't know. Anyway, but
this is interesting. But what I didn't say, which I think is important in relation to referenda, is that there's a structural problem with the idea of a referendum, which is that the people who promote a yes answer or a no answer are not the people who are responsible for the consequences of that vote. Therefore, it's easy to say anything you like because nobody's going to hold you responsible for it. So, you get manipulation, you get lies, you get at a level which would not be possible in an ordinary election because you are held to account for what you say. But what happened with the Brexit one is that they lie and then they get the result that they want, and then they say, oh, but it's not my responsibility to implement this. And guess what? The people who did it, they're completely wrong, and that's not what we intended, because you just have no responsibility. And I think that there was something of that in the Australian case, because there were reports about people saying, oh, I can't support this amendment because it means that the Aboriginal people will come and turn me out of my house. Mm-hmm. Right? I mean, this is kind of the sort of propaganda that you get that is a direct result of it being a referendum, not a general election. Yeah.
Yeah, it was proposed, I think, as a kind of feel-good proposal, that everyone in Australia could be happy, give the Aboriginal people more voice, and it won't cost you anything individually. But the campaign against it was, as I understand it, exactly as you said, putting out consequences that might be visited upon by ordinary people, which in fact would not probably have happened. But what I wanted to ask you about was the criteria for apportionment in Malaysia, because I take it there's no one person, one vote provision of the Constitution, and you said it's heavily weighted toward the rural areas. So what are the rules by which districts are drawn?
I mean, it is one person, one vote. It's not one person, one vote, one value. That's the difference. So your vote in, shall we say, Putrajaya electorate 17,000 is worth 10 times the vote in Damansara population 117,000. I mean, basically, that would be unconstitutional in almost every country because, you know, to take again Australia as an example, you cannot have more than a 10% divergence between one district and another district. Everybody has to be roughly, I mean, you can't be absolutely, obviously, but roughly within the same margin, and that margin is 10%. And in other countries, there's a prescribed margin of error, whether it's statutory or constitutional. I mean, you know, that is the restriction on this malapportionment. And that's what used to be the case in Malaysia until the government secured an amendment saying that, you know, that doesn't apply anymore, and you can weight constituencies in favor of the rural interests. And that was justified on the basis of, well, cities already have a lot of advantages, therefore let's give an advantage to the rural areas to counterbalance what the cities had. But of course, that was run with to such an extent that the balance has so shifted completely out of kilter now in favor of the rural areas. And because the drawing of the districts can only be done once every 8 years, it cannot be done again until 2026. So the intention is absolutely to say, well, I mean, this is simply not tolerable, but constitutionally, we can't correct this until about 2 years' time, hopefully before the next election takes place. But this could have a dramatic effect on, you know, on the actual outcomes in terms of numbers of seats, because this is going to re-empower the urban areas, and therefore certain parties are going to benefit from this, you know, in quite a big way. It will be interesting to see. But, you know, the Election Commission is working on this, but they can't do anything until the time comes.
And the tripwire seems to be 4-1, and the if the legislative malapportionment gets to be 3 or 4-1, the courts will huff and puff, and they will tell the legislature, the Diet, that this is in what they call a state of unconstitutionality. They don't say it's unconstitutional. They have this kind of weasel word phrase, state of unconstitutionality, which is supposed to be a strong hint to the Diet that it needs to reapportion, but the Diet seems to often not get the hint, you know, and it's, oh yeah, okay, well, we'll think about it. But what the courts have never been willing to do is strike down an election, you know, to say that an election because of malapportionment is unconstitutional. It has never done that, and I think never will.
Right, I was just thinking about the solution to this fixed majority clause problem that Andrew said, that a 2/3 majority, I mean, that is really like a random choice, because it then depends on the political majorities that are actually in place. Now, what would you think of a flexible majority rule that basically says, you take the percentage of the governing coalition plus 20%. So that, for example, when Barisan Nasional had 70%, they would need 90% for the change. Or if they now only have 45%, or I mean, anywhere, then you would need 65%. So, I mean, just to save somehow the majority clause, because I think it's still, in the end, if we agree that we need a representative body to decide, if we do not want to have direct democracy in the actual vote, then some kind of a chamber needs to decide, and we want it still to be somehow that the opposition also gets a say in it. So we want somehow this kind of a and supermajority, but the fixed rule may not be that smart, I agree. But what do you think of that kind of a flexible rule that just adds plus 10, plus 20 on the current majority that the governing coalition has?
That's a really interesting suggestion. I mean, as a matter of interest, is there any country where they have that rule? You know, because I think you could be in business here, you know, as a constitutional consultant, or you know. I mean, it's really interesting, but honestly, I think I'd still be a little bit suspicious because, you know, even opposition parties can have their own dubious political agendas when it comes to constitutional amendment, either proposing or, you know, or rejecting them. I mean, if you look at the whole history of the Fixed Term Parliaments Act in the UK, for example, where that was introduced and then was finally abolished, leaving us with the extraordinary situation that one elected official standing in the rain can decide that we're having an election on the 4th of July, even though apparently most of his own MPs think this is a very bad idea. You know, so I mean, you know, there's scope for a lot of improvement. I'd need to think about your particular proposal. It's quite ingenious and, you know, you know, creative and thoughtful. But I think we'd have to think through what the implications might be. A member of the public might say, but why are you giving this extraordinary determinative power to one political party or a group of parties who happen to be in opposition? I mean, that's rather like saying, well, you know, then we should consult the bishops. Well, I mean, why the bishops? What gives them, you know? Well, okay, those MPs are sitting in Parliament. They are actually elected and accountable to the electorate. But the fact that you're in opposition doesn't necessarily make you right. The fact that you have a two-thirds majority in Parliament doesn't make you wrong, right? And maybe we just need more interests to be involved in this. To what extent you should prescribe that by law might be another interesting question, because there's a huge variety in practice in terms of, well, who gets to have a say in a constitutional amendment. I mean, ranging from everybody to almost nobody, and lots of positions in between. I mean, one interesting example is in South Africa, during 1993 to 1996, the Constitutional Court had the power to pronounce on constitutional amendments as to whether they were consistent with the original political declaration or whatever it is they called it in 1993. So maybe there's even scope for judicial involvement in this process. But I think at the very least, we need to have a conversation around what is involved in this. And I think that we're all pretty clear that what we see around the world is generally just not adequate to the purpose, because either it becomes undemocratic, or it simply becomes impossible to amend the constitution even for very good reasons. So we have the sort of, you know, the Scylla and the Charybdis, and finding a route in between the two seems to be very, very difficult.
Thank you very much. I was planning to continue about Professor Lee's inform, but I'm not sure whether Indonesia is actually a good example for that. Because if you would like to amend our constitutions, then you need to, the plan should be approved by 2/3 plus 1. So it's not like 20% or 10%, but 2/3 plus 1 of the parliament. But Professor Andrew is more expertise on this Indonesian constitution, because I'm not a constitutional lawyer. But I think in one of the articles, if I'm not mistaken, in Article 37, it mentioned that should be approved by 2/3 plus 1. And another comment is for involving the academics to work more on society. I think Indonesian lecturer, Indonesian academics, we have one task. We call this like community service, and most of the time, well, not once or two times per year, we usually come to the community to give a kind of education for the people on any issues, not only related to constitutions, but also maybe for the new law that are adopted by the parliaments. So that's what we do, basically, other than teaching and research. Also that we still have civics education until, even I think until the first year of bachelor. But that does not agree, that does not always prove that our people actually knows the Constitution as well. Because maybe they know the text, but for the practice, it is also really depends on the parliament and also the presidents. For example, like what's happening with our current presidential election last 2 months, that basically, actually, it's really far from the constitutional practice. So it's we work on that, but civic education as well as community service might not working that much, at least in Indonesia. Thank you.
Thank you. This is very interesting. The internal perspective is always a bit different from the external perspective, but it sort of seems to me Indonesia is actually a very positive example of constitutional amendment, because you've only had 4 constitutional amendments. 4, I think. 1999, 2000, 2001, 2002. 4, and actually all of those amendments were extensive, and I think they were good amendments, and they carried a lot of political support. And there haven't been any other amendments. I'm not saying nothing bad has happened, but nothing bad has happened as a result of a direct result of a constitutional amendment or of failure to achieve a constitutional amendment. So this, to me, seems to be a pretty good record. And if I might just refer to Myanmar as an opposite example, you know, for 10 years they had a rule where you had to have 75% plus 1, and the plus 1 was impossible because that was controlled by the military, and they will never agree to a constitutional amendment, and therefore the constitution could never be amended. And it was therefore the most rigid constitution on the face of the planet, because there was literally no way of amending the constitution. And people were looking at Indonesia as an inspiring example of what might be possible, if only. So I think we can learn a lot from your example.
Just want to add some comment about referendum and constitutional amendment that you just mentioned. I think in Thailand the referendums was introduced first time in 1949 Constitution. But if you look at the drafter of that Constitution, their purpose to include the referendum in the amendment process is to give the king a tool to protect himself against constitutional amendment that will endanger the throne. They say exactly that. So that's the first time when a referendum put into the constitution in Thailand, right? And I think that like from then until present day, referendum in terms of constitutional amendment in Thailand still serve the same purpose to protect something. But like if you can see from the referendum for the current constitution and the last 2003 constitution, you can see that when they realize that the civic society can go against the constitution, they just add on some element like to prevent someone to go campaigning against the referendum campaign that promoted by the government or something like that. So this is just like kind of general practice in Thailand, I think. Yep, thank you.
This, I've been living in Japan for a long time, and this is a 50-year debate in Japan. In Japan, the Constitution requires a 2/3 majority of both houses, plus a majority of the general citizenry to make a constitutional amendment. It's never gotten a 2/3 majority of both houses, so it's never gotten to that point. Former Prime Minister Abe, who was assassinated a few years ago, one of his main reasons for existence, by his own admission, was changing the Constitution. And the irritant to him and to many members of his party is that it was largely drafted by the United States. He called it a masochistic kind of constitution, which refuses to allow Japan to have a full-fledged military and things such as that. But the other day was Constitution Day in Japan. The newspapers always do surveys. Do you want to revise the Constitution? And the numbers vary. The other day there was a slight majority in favor, but some years it's not a majority in favor. I think the dilemma is it's never been amended. It's never been amended, right? And the dilemma is that probably the majority of people think that it's time for the people of Japan to write their own constitution, but they fear that if that happens, they'll get a much worse constitution than the one they have now, which is probably true, that's a serious dilemma, I think.
This is a very interesting example, which sort of prompts one to think about what the authority of a constitution is, and therefore the sources of the constitution become important. So if you perceive that your constitution was imposed by a foreign power, then obviously it doesn't have the same cachet as a constitution you drafted yourself. And again, Indonesia is a good case in point, because essentially what happened with the amendments is that they adopted a new constitution, but they didn't call it that. They called it a series of constitutional amendments to the original constitution. In Thailand, it would have been easy. Well, you just, have a new constitution. Why didn't they do that? Well, our friend from Indonesia can probably answer this better than me, but I think because the 1945 constitution means something. Yeah. Right? It would be, imagine if in Britain people said, well, let's repeal the Magna Carta, right? So we don't have to give people jury trial or something like that. There would be a revolution. Not that people know about this, they haven't a clue, but they just are emotionally attached to the idea. There's something fundamental to do with identity, which you don't get from a foreign imposed constitution. But just thinking back again to the Malaysian context, one reason why this constitution has survived and Thai constitutions don't is because of exactly what you say, that it's not that everybody loves the Constitution equally, it's because everybody hates the Constitution equally, right? And that once you start, you don't like the Constitution, but once you start to unravel it, then these people will get their Constitution. We don't want them to get their Constitution. We'd rather stay with the bad Constitution because it sort of works for most people most of the time. Yes, it's not ideal, but it can always be improved, right? Much better than having a constitution-making exercise where you don't know what the outcome of that might be. It could be horrendous. Look at the process that they had in Chile, for example, where everybody got what they wanted, except that nobody wanted the whole package, right? Because everybody got what they wanted. It didn't make any sense. So, it's a case of, the saying that a camel is a racehorse designed by a committee, right? Because, everybody has a different idea. You finish up with something that doesn't really work.
All right, so sorry for keeping us a little bit longer. Now, Andrew, as you are in Thailand here, you can speak openly about Malaysia, which is great, because I was just thinking about a question. So you just mentioned this fascinating proposal about that citizenship amendment that has issues of gender equality connected to it. That just raised to me again the question that every now and then people may discuss in Malaysia whether the position of the Malay population as protected in the constitution shall be subject to some kind of a change or modification. Do you think that that topic may come up again now that the constitutional amendment process seems to be a bit more consensus and maybe even deliberation based, not that much dominated by one political actor? Or do you think that that is an issue that just stays as it is?
That is a really, really good question, Lasse, and it's a problem answering it because it is not just the most important, I think, constitutional question. It's also the one constitutional question that cannot be discussed, right? So the first point would not be what should be done. The first point would be, is it possible to have a discussion about what should be done? And the answer is currently no, because it is actually technically a criminal offense to discuss this, in the sense of questioning whether it should be the case or not. I mean, you can discuss it in the sense of saying what a great thing it is. I mean, but you can't sort of critique it and say we should have a different system, except that occasionally some politician can get away with that, and you sort of think, well, but haven't you just committed sedition? And, well, yes, but you can get away with it because you are who you are. So a lot depends on who is saying it, and what they're saying, and why they're saying, and to whom they are saying it, right? It depends on all of those things. So you can't have a thorough, intelligent public discussion about what should be done about this issue of socioeconomic distribution, as you could in South Africa and have in South Africa, for example. And there's a lot of similarities in terms of the demographics and the socioeconomic problems and so on there, which people have, discussed. But ultimately, the politics is aligned against making any change because the Malay Muslim population is increasing all the time as a proportion of the whole. It used to be less than 50% in colonial times. It's now creeping up somewhere close to 66 or 67%. And a substantial number of those people will be extremely against even a discussion about what should be done about it, because they think that that will lead to their rights being taken away. And yes, you can argue that if you are able to publicly argue, which you can't, but you could argue in theory, well, this was only ever supposed to be a transitional provision, and therefore there must be a point where it comes to an end. Otherwise, it is a pointless. It's pointless because it's never going to achieve its objective. There has logically to be an end point. Logically, yes, but politically, no. So that's, I think, about the size of it. A lot of other things would have to change before you could have a real discussion about that. And you cannot even really sort of research and produce facts showing that what has actually occurred, even without saying whether it's a good or bad thing. You can't even do that, because if it differs from what the government says, then you are going to be in very big trouble. And there have been cases of that, where, I mean, for example, an economist said, well, all of this sort of, redistribution, well, actually, we've already achieved this. I mean, look at the figures in terms of Bumiputra ownership and so on. And there is a question about how you judge this. I mean, economics tends to be very subjective in that way. What do you take account of? But he argued persuasively that the 30% benchmark had long been superseded, and now it was 40%. And the government said, no, it's not. It's 19%. And you are wrong, and you will now leave your position. Otherwise, there will be trouble. So that's where it's at, unfortunately.
Okay, thank you very much, everyone, for attending this conference. I think it's about the time that we should, close this public talk. Once again, on behalf of the Faculty of Law, I would like to express our special thanks to Professor Andrew Harding for, joining with me to, to deliver this lecture. And I hope that we will arrange, another one in the future soon. And again, thank you very much for attending the event. Thank you.